Let me mainly start out, Governor Barber, by thanking you on behalf of Mississippi's physicians, healthcare providers, patients, and citizens. Your leadership a decade ago in passing tort reform led to a resuscitation, a stabilization, and recovery of a dying medical practice environment in Mississippi. As Neely said, I am a professor at the University of Mississippi Medical Center, and we train healthcare providers oftentimes by presenting cases to them to give them a mental picture of the condition of their patient that they're trying to treat and the healing they're trying to do. So let me just take you back to class in pre-2004 healthcare climate. The healthcare delivery system is in a state of crisis. Doctors were leaving the state due to the number of lawsuits being filed against them. Malpractice insurance rates were increasing at double-digit rates annually. And most medical malpractice insurance companies left the state. Doctors who could were retiring at an earlier than expected age. Others were cutting back on the high-risk parts of their practice, and the numbers of patients that these doctors were seeing stabilized or declined. OBGYNs stopped doing the OB part of their practice. Most neurosurgeons left the state, and the few that remained would not cover emergency services. Emergency room physicians fled the state to more friendly physician practice states. The University of Mississippi Medical Center medical students were seeking to go out of the state to continue their training in out-of-state residency programs. Residency programs at the University Medical Center saw some reluctance in medical school graduates from other states looking to do their specialty training here at the University Medical Center. For those residents who did train at the University Medical Center, most planned on leaving the state to begin their practice outside of Mississippi. The number of physicians applying for licensure from out of state to the Mississippi Board of Medical Licensure experienced a dramatic decline. The University Medical Center saw an increase in difficulty to recruit academic physicians into its teaching ranks. Even the Mississippi High School Athletics Association experienced a negative impact to its programs as physicians who previously did athletic physicals on a voluntary basis stopped doing them for fear of lawsuits. Mississippians experienced a major problem with access to care as all of these issues coalesced to form the perfect storm in creating a crisis in Mississippi's healthcare environment. The United States Chamber of Commerce said in 2002 that if you were pregnant in Mississippi, you needed two things: a set of car keys and a tank of gas, because many OBs had again closed the OB part of their practice, and almost all family medicine physicians quit providing OB care. Sadly, many pregnant patients in rural areas and even communities like Kosciuszko had neither of these two things, and there were reported cases where women delivered on the side of the road on their way to Jackson or Starkville where they could still obtain OB care. Two separate motor vehicle accidents in different parts of the state serve as good illustrations of the damage being done to Mississippians due to a lack of specialty medical services in the state. And in these two cases, it's in neurosurgery. The first case is a middle-aged businessman returning home from a business trip to the Mississippi Gulf Coast. He was involved in a single-vehicle automobile accident and sustained a subdural hematoma, which is bleeding on the brain. He was taken to a large hospital on the Gulf Coast, but there was no neurosurgeon there to do a brain-saving emergency procedure to relieve the pressure on his brain. He was transferred to the University of Mississippi Medical Center, but by the time he arrived, he had sustained permanent brain damage. He survived the incident, but he was permanently disabled. The second case involves a young adult who was involved again in another motor vehicle accident in Greenwood. Both local neurosurgeons had closed their practices. One decided to retire, and the other just left the state. This patient was taken to the local hospital and transferred to the University Medical Center, but by the time again he arrived, he had sustained permanent brain damage. He died 1 month later from his injury. Then we get to 2004, and the Mississippi legislature passes and the governor signs the 2004 Tort Reform Act, the climate immediately starts to improve. 1 year later, 2005, medical malpractice insurance rates have stabilized, and for the first time in years, malpractice insurance rates did not increase, and there is indeed discussion of reducing rates or giving refunds in the years to come, just 1 year later. Other malpractice insurance companies now start looking at coming back to the state to write policies. The number of medical malpractice lawsuits have declined sharply. Premiums that had risen more than 10% each year between 2000 and 2004, including a 45% increase in 2003 alone, saw for the first time a non-increase in premium prices. University of Mississippi Medical Center medical students are now again starting to look at doing their residency training in Mississippi. Medical students from outside of the state are now seeking residencies in Mississippi, and the recruitment outlook for the University Medical Center faculty is improving. Graduating University Medical Center residents are now looking for practice opportunities in Mississippi. The number of practicing physicians that had dropped by 460 physicians in just 1 year between 2003 and 2004 saw an increase of 116 physicians in 2005, and that trend remains positive to date. So, Governor Barber, our healthcare system is out of critical care. It's continuing to recover. There's still work to be done to take us from being the state with the lowest number of physicians per population. But thanks to tort reform, the environment is more inviting to healthcare professionals to come here, to stay in Mississippi, and to provide care to our citizens. I thank you for the opportunity to speak, and I thank you for the work that you've done.
3 quick messages: courage, measurement, and tenacity. They are the 3 things we've got to focus on, I think, both today and in the future regarding tort reform and keeping our competitive edge. I'm not going to go into a lot of detail. We've talked about the success, but let's talk a little bit about courage. You know, it's an old medieval saying that he who sticks his head above the crowd runs the risk of being hit by rotten fruit. And I will tell you, there was a lot of rotten fruit flying back in the early 2000s. This was not a popular issue across the general part of Mississippi at first, because at first there was a misunderstanding that this was something that affected other people. This affected out-of-state corporations. This wasn't really a Mississippi. That's what was being said back then. But I really need you to understand what this guy here did. Back then, there was a talk about a need for a Mississippian to be willing to stand up and stick his head above the crowd. It's easy for Jay Moon or Clinton Graham or myself to do stuff like this because we get paid to do it. We're association leaders. It's our job to go out and take a position. But for Lex Taylor to take the lead, go around the state, and for several years put his family business essentially on hold as he went out and led this, took a remarkable amount of courage and tenacity. Very, very unique. Lex, thank you. Teamed, yes, sir. Teamed with Governor Barber's exceptional leadership in this role, this issue picked up the momentum. And if you wonder about what kind of momentum was there, look at these messages from home that folks sent the legislature by fax, little pink messages from home. But instead of saying, while you're out, this said, we care about tort reform. Thousands of responses in a week's time. And every legislator got a spindle like this. Some of them had an idea what I could do with that spindle. But anyway, every legislator got one of those spindles to send the message. That's what it took. Now, how are we doing? There's a lot of stuff out there on tort reform that tracks its success. I think the best research model is a research document from the Pacific Research Institute out in San Francisco. Because unlike some of the groups that do public opinion surveys, this group actually analyzes both inputs and outputs relative to tort reform climates, civil liability climates in every state. Now let me tell you where Mississippi ranks in the last one done in 2010. We rank number 3 for tort rules, meaning, you know, the basic rules of civil liability. We rank number 3 behind, we rank number 5 nationally behind Oklahoma, Texas, Ohio, Colorado, and we're Mississippi. We're number 5. Among the blueprint states, those we compare ourselves, those states that we compete with for economic development projects, we rank number 3, behind only Oklahoma and Texas. That's remarkable. That is remarkable. We are in the top tier among our blueprint states regarding tort reform rules, the law. We rank number 21 in overall nationwide tort risk. That's all kinds of outputs. That's judges, that's juries, that's, you know, the whole climate. How do people think? We rank number 21. But among our competitor blueprint states, we rank number 5. Number 5. Only behind North Carolina, Louisiana, South Carolina, and Texas. Again, that's remarkable. So the next time folks are saying, well, Mississippi is always running behind, look at this document. The governor and MDA printed this about a year ago. We reprinted it because they hadn't printed enough copies, and I handed it out to you today. I'm glad the governor talked about it because I wanted you to see it. This is what tort reform did. If you can sit there and say, well, what really were the results? The numbers I just gave you, that's what happened from tort reform. Now, where do we need to go in the future? We've got to stay ever vigilant because these numbers change every year. Other states are, in fact, changing their civil justice laws all the time. Standing still is falling backwards. So my lead-in, really, for the next panel and for the discussion that may go on here when I'm done, is let's have a dream about how we get even higher, how we continue to move up and improve our opportunities for the future. Walt Disney was a great dreamer. He wrote the lyrics for his first theme song in his movie, Cinderella. A dream is a wish your heart makes. He wrote those lyrics. And he was a great dreamer. But he was also a business leader. And he understood what it took to be successful in business. Focus, focus, focus. And that's where we have to be. We have to be off our seat and on our feet to continue to maintain this competitive edge. And the way you know that Walt Disney was really a business leader, he said all your dreams really can come true if you have the courage to pursue them. Lex Taylor had the courage. Many of you had the courage. Let's keep that tenacity in place and have the courage to continue to move forward. Thank you.
I want to thank Governor Barber for including me in this. I was a freshman legislator in 2004 when we passed tort reform. I'd been in the legislature all of 3 months and didn't know a whole lot. And Governor Barber was very kind to me. He included me in some of the discussions. He allowed me to tell him my ideas and my thoughts. Best I can tell, he did not adopt a single one of them. But nevertheless, he was patient and kind and listened to me. I always thought I had at least one contribution. That was, he called me after the regular session ended and he said, I'm debating between calling you right back now, immediately, or waiting 2 months. And I told him I felt like we ought to go back right now. And I thought until today that I had influence on him, but I've learned that it was actually Marcia Barber. So I didn't even have an input on that. I also want to acknowledge the contributions of 2 gentlemen in the House of Representatives that made this happen, and that's Jim Simpson and Jeff Smith. Those 2 guys led the charge in the House of Representatives. They're the ones who made it happen in the House. They were kind enough to include me in some of the discussions that took place over there. They actually permitted me to offer an amendment on the House floor to the bill, and they both voted against my amendment. So I didn't even have an influence there. The main thing I remember about tort reform was that we had kind of reached a log jam. There was a stalemate of some sort over a number of different issues, and I don't even remember what they were now. But a meeting was called of all the Republican attorneys in the House. As I've told Governor Barber many times, the problem from 2004 to 2010 was the House of Representatives. The House of Representatives was where good legislation went to die. And I said, until we change the House of Representatives, we're going to continue to see good policies and good legislation die. And this was a prime example of that. Tort reform bill, as he said, passed the Senate 6 times, died in the House 6 times. Good piece of legislation that we couldn't get passed. So there was a stalemate of some sort. I don't even remember what it was. And they called a meeting of all Republican lawyers. So there was 10 of us. So we get in a room, and the senior members decided that they all had too much baggage, too many battle scars, that they could not gain the trust of the other House members. And they needed some fresh meat, some fresh blood to help get past the logjam. So they nominated me and Mark Baker. I saw Mark earlier. Where is he? There he is. Me and Mark Baker and Virginia Carlton were elected to rewrite the tort reform bill. Now remember, we've been in the legislature 3 months. We were like a cow staring at a new gate. We didn't know what to do. So we took the bill and we rewrote it as we thought it should be. And I got elected to present that amendment on the House floor. This is the 3rd time I'd ever been to the well of the House. First time I ever went, I was arguing an education bill. And I'd been on the school board, so I figured I knew a lot about school board matters. So I went to the podium and I argued against this bill. This is a bad bill. You should vote against this bill. I went back to my seat and they called for the vote and the board lit up entirely green. I didn't persuade one person to vote with me. So I chickened out and I voted for it too. And the second time I went to the podium, or to the well of the House, was to present the Home Warranty Act. So this is the 3rd time I'd ever been to the well of the House. Our amendment didn't pass, but we did present some ideas that were adopted, and it helped break the logjam. And 2 days later, we passed this bill. So thank you for allowing me a few moments of personal reflection as I recount my experiences with tort reform. I have been asked today by the governor to address one of the things he just mentioned, and that is the appeal bond process. I'm limited in the amount of time I have, so I want to just touch on a couple of items. But one topic I want to talk about is this appeal issue that he just mentioned a second ago. A lot of people ask, is there anything more we can do in tort reform? And before I get to this, let me just say I agree with the governor wholeheartedly in that we have got to stand guard on what we've passed here in Mississippi. There are constant attempts every year to undo what we've done, and they're not blatant. They're very subtle. But I watch the bills as they are filed and they come across my desk, and there's a constant effort to create a standard, to create a duty of some sort, so that a lawsuit can be filed. If I charge you with a duty to do something and you don't do that, then I can sue you over it. And we have to be on constant guard. As the governor said, this battle is not over. We have fought this battle, and we've got a lot of great things to celebrate. But there's a constant attempt every year to undermine what we've accomplished. And we are standing guard to do that in the House and in the Senate, making sure those bills do not weaken or roll back the efforts. So just be, as the governor said, rededicate yourself to this cause. We have got to stand guard every year to make sure that it's not weakened. So that's one thing we're doing. Another thing we're doing is this appeal bond area, and I want to address that for a few minutes here. As the governor mentioned, Mississippi Rule of Appellate Procedure 8 is the rule that sets forth the terms, the conditions for appeal. And in the way of an explanation, anytime a defendant appeals a verdict, you have a lawsuit, the defendant gets sued, and he loses, and he's got a verdict against him, and he wants to appeal that, he's got to post a bond of some sort. The problem that this presents in many cases is that the verdict is so enormous and so large that the appeal cost is prohibitive. This means that any time you have a case in which there's a bad decision or a bad verdict, It doesn't get appealed because the defendant can't afford the cost of appeal. This results in an injustice to the defendant, and it results in potentially bad case law, a bad decision being issued. Many states have recognized this problem and have done something about it, and they've taken measures to correct it. Over the last 14 years, virtually every state has imposed limitations on the size of the bond that must be posted by the defendant. Prior to the enactment of these reforms, in most states, the defendant was required to pay into the court an appeal bond equal to the amount of the judgment. And in many states, they had to pay anticipated interest and cost. Mississippi led the charge in 2001 in changing this when the Supreme Court amended the Mississippi Rules of Appellate Procedure so that the appeal bond related to the punitive damages would be limited to the lower of 125% of the amount of punitive damages, 10% of the defendant's net worth, or $100 million. This is a good and sensible reform. It moved us in the right direction. And following our action, following what we did in Mississippi, 40 other states enacted similar legislation and reformed the appeal bond process. In addition to those 40 states, 5 other states already recognized that the appeal bond process was a rather antiquated measure, dating from the time when the defendant would get on his horse and ride out of town and you never see him again. But most states still require an appeal bond. In every other state that in every state other than Mississippi that has adopted the reforms, the appeal bond limit applies not just to the punitive damages portion of the judgment, but to all the damages. This recognizes that many of the largest suits are now class actions. They are breach of contract actions that involve billions of dollars, and the judgments sometimes can be enormous. In such cases, the compensatory damages portion of the judgment is also included or considered in the appeal process. So over time, a consensus has emerged that the appeal bond limits should apply to all damages awarded in the case, both the compensatory and the punitive. In addition to the broadening of the limits to apply to all kinds of damages, many of the states have adopted a limit lower than the $100 million that we have here in Mississippi. And a good number of states, the reform measures make clear that the limits apply to all the damages. With respect to the size of the appeal bond limit, 27 states have a limit less than our $100 million limit. Generally, it's $25 to $50 million. I'll read to you here some language from Texas. This is a good example of what I'm talking about. In 2003, the Texas legislature passed a provision that states when a judgment is for money, the amount of the security must not exceed the lesser of 50% of the judgment debtor's net worth, or $25 million. In Arkansas, they passed a similar provision that provides the maximum appeal bond that may be required in any civil action shall be limited to $25 million, regardless of the size of the judgment. These are just 2 examples, but interestingly enough, there are no reported cases that show where the plaintiff, because of the implementation of these reforms, the plaintiff was barred from his recovery, or that the plaintiff suffered any ability to gain his judgment in the event the verdict was upheld by the Supreme Court. So in other words, the appeal bond limitations are an example of a highly beneficial reform that has presented no problems in states where they've been implemented. I think this is something Mississippi should consider, something we ought to look at. It is something that I've been trying to push for over the last couple of years. I've been working with the Supreme Court to try to get this done. They are interested in this process, but we might consider doing this through legislative action. We might consider lowering the bond amount from $100 million to $25 or $50 million. The second issue I would like to address is whether or not we should retreat from the reforms. There's been some suggestion that we should roll back or soften up the reforms that we have passed. And I'm here to say that I adamantly say no to that. All we have to do is look at the prosperity that Mississippi has enjoyed over the last 10 years. The doctors have returned to the state to provide medical assistance to our citizens. Businesses have blossomed. Jobs have been created. It seems that Governor Bryant is somewhere every week welcoming a new business to our state. Our people have jobs. Our economy is outpacing the nation's economy. Insurance rates have declined. There are going to be others here today to talk about the great benefits that we've seen over the last 10 years. But I'm here today to say that as long as I have anything to do with this, we're not going to take a step backwards. We're not going to roll back or soften up the tort reforms that we've implemented, and we're not going to return to the days of jackpot justice that we have gone away from. Those of us in the Mississippi House of Representatives are going to continue to stand strong to make sure that Mississippi is a stronger place in which to live and to do business. Finally, I would point out one of the big lessons that we learned from tort reform, and that is good policy affects great improvement, but sometimes it takes change for that improvement to be realized. After we passed tort reform, we cautioned everybody, you know, this is not going to be an immediate. It's going to take a while. You got to give it a while. We got to let the current lawsuits run through the system. It may be 5 or 6 or 7 years before we see the fruits of tort reform. And that's exactly what happened. We're here today, 10 years later, looking back to see all the great things that I just named that have happened, but it took time. And that's the lesson I think that we've got to take from this, looking forward. Sometimes good policy takes a while to effect an improvement. The lesson learned here is that good policy makes great improvements, but sometimes those improvements take time to occur. And that's exactly what we're doing now in the legislature. Under the leadership of Governor Bryant and the Republican-controlled House and Senate, we're passing good policies today that pertain to budgeting, pertain to spending, pertaining to health care, pertaining to education. And all of these are going to make tremendous improvements in our state over the next 10 years. It may take time for these policies to make improvements. We have to be patient, but the good policies result in good government, and that's exactly what we're doing at the Capitol these days. And hopefully 10 years from now, we can have another meeting like this. We can gather up and we can say, look at all the good policies we've passed that have improved education, that have improved health care, that have created jobs, that have gotten spending under control. And hopefully we can have another meeting like this where we can celebrate the good policies that your current legislature is passing today. Thank you so much for letting me be with you. Appreciate it.